Hello, this is R.J. Deacon reading the slip opinion from the Supreme Court of the United States in United States versus Microsoft Corporation. Finding of mootness. On writ certiorari to the United States Court of Appeals for the Second Circuit. Per curiam. The court granted certiorari to this case to decide whether, when the government has obtained a warrant under 18 U.S.C. 2703, a U.S. provider of email services must disclose to the government electronic communications within its control, even if the provider stores those communications abroad. 583. In December 2013, federal law enforcement agents applied to the United States District Court for the Southern District of New York for a 2703 warrant, requiring Microsoft to disclose all emails and other information associated with the account of one of its customers. Satisfied that the agents had demonstrated probable cause to believe that the account was being used to further illegal drug trafficking, a magistrate judge issued the requested 2703 warrant. The warrant directed Microsoft to disclose the government the contents of a specified email account and all other records or information associated with the account, to the extent that the information is within Microsoft's possession, custody, or control. After service of the 2703 warrant, Microsoft determined that the account's email contents were stored in a sole location, Microsoft's data center in Dublin, Ireland. Microsoft moved to quash the warrant with respect to the information stored in Ireland. The magistrate judge denied Microsoft's motion, in re-warrant to search a certain email account controlled and maintained by Microsoft Corp. The district court, after a hearing, adopted the magistrate judge's reasoning and affirmed his ruling. See in re-warrant to search certain email account controlled and maintained by Microsoft Corp. Soon after acting on a stipulation submitted jointly by the parties, the district court held Microsoft in civil contempt for refusing to comply fully with the warrant. On appeal, a panel of the Court of Appeals for the Second Circuit reversed the denial of the motion to quash and vacated the civil contempt finding, holding that requiring Microsoft to disclose the electronic communications in question would be an unauthorized extraterritorial application. The parties now advise us that on March 23, 2018, Congress enacted and the President signed into law the Clarifying Lawful Overseas Use of Data Act, Cloud Act, as part of the Consolidated Appropriations Act of 2018. The Cloud Act amends the Stored Communications Act by adding the following provision. A service provider shall comply with the obligations of this chapter to preserve, backup, or disclose the contents of a wire or electronic communication and any record or other information pertaining to customer or subscriber within such provider's possession, custody, or control, regardless of whether such communication, record, or other information is located within or outside of the United States. Soon thereafter, the government attained, pursuant to the new law, a new 2703 warrant covering the information requested in the 2703 warrant at issue in this case. No live dispute remains between the parties over the issue with respect to which certiorari was granted. See Department of Treasury, Bureau of Alcohol, Tobacco, and Firearms versus Galotto. Further, the parties agree that the new warrant has replaced the original warrant. This case, therefore, has become moot. Following the court's established practice in such cases, the judgment on a review is accordingly vacated, and the case is remanded to the United States Court of Appeals for the Second Circuit, with instructions for the first to vacate the district court's contempt finding and its denial of Microsoft's motion to quash, and then to direct the district court to dismiss the case as moot. It is so ordered. Thank you for listening.